Sooner or later, these vacancies have to be filled. The filling of these vacancies calls for appointment of new justices. This is where the body of senior advocate has issues with the method of selection and appointment of justice of the appellate court. The body has said it times without number and in various fora that the method of selection of candidates for appointments as justices in the Supreme Court and the Court of Appeal is unsatisfactory in the extreme. The appointment process appears to have been designed and operated to exclude good and competent lawyers in legal professions from being appointed justice of our appellate courts. There are two aspects of this restrictive policy by the appointing authorities. The first is that the appointing authorities appear to have established a policy that vacancies created by exit of a justice of the Supreme Court or the Court of Appeal are to be filled by picking a candidate from the state of the vacating justice only, notwithstanding the availability of known better candidates readily at hand from other states or local governments in case of judges at the trial courts. The consequence of this policy is that by it, our nation, our citizens, foreign citizens, and foreign and local businessmen and women who use and are expected to resort to the courts of law for restoration of their problems in Nigeria are denied the opportunity of having their cases considered and decided by appellate courts manned by the best legal minds the nation can produce at any time. This is a very sad reflection in our nation and the nation's judiciary. The policy of geographical spread in public service and in public life appointment is acknowledged today to be the foundation for the mediocrity and incompetence in some areas of the public service of our nation. The risk and dangers of mediocrity and incompetence in the Nigerian judiciary is too grave to permit by the policy of replacement or exclusion. The theory of replacement cannot bring about the best that is in us, the legal profession. At independence, many English and Commonwealth judges left the country. Their replacements were picked from among the best lawyers and judges of the time. The Right Honorable Justice Adetokunbo Ademola was lifted to the Supreme Court of 7 justices as CJ to man our courts. After all, justice is blind and so does not look at the face or see the face of litigants. Justice knows no tribe and has no color or religion. It has no specific location because it's everywhere. Let no one put on the Nigerian judiciary the ironclad case of restricting the appointment of justices in the manner we have complained about. Another sore point on the appointment of justices in our nation is the continued resistance or rejection of the necessity of appointing justices directly from the bar, as is the practice in other countries. Presidents are bound in Nigeria. Honorable Justice Namani was not at any time a High Court judge. Yet, from the seat of Attorney General, he was appointed to the Supreme Court. The records of how Honorable Justice Namani performed on the Supreme Court bench are there for all of us to see in his judgments in the law reports. The Right Honorable